Okay, students. Now we are moving towards our next topic, that is the transnational crimes, terrorism, and torture, and thereafter corruption. To focus only on the core crimes and their prosecution uh, would be to ignore a substantial area of the criminal law with international implications. There are other crimes of international concerns which have a huge impact on the people throughout the world and non-global economic development. Crimes which are the subject of the international surveillance conventions, but for which there is yet no international criminal jurisdiction, are the focus of this lecture. They are here termed transnational crimes. Like the core crimes, so students, here are the slides of this topic. I hope it is appearing on your screens. So now we are again crimes which are the subject of the international suppression convention, but for which there is yet no international criminal jurisdiction are the focus of this lecture. They are here termed transnational crimes, like the core crimes. These are crimes which have actual or potential transboundary effect, or which are intra state, but which offend a fundamental value of the international community. The prevention and punishment of the transnational crimes require cooperation among the governments and among law enforcement agencies. A growing number of the agreements are being concluded to provide for this in relation to such crimes as drugs trafficking, piracy, slavery, terrorism offenses, torture, and enforce disappearances and further transnational organized crime, including people trafficking, smuggling, migrants, and illegal arms trafficking, and corruption is one of the major core crime, which is nowadays the concern of the states. Some of these are also covered by the customary international law or are international crimes when committed in certain circumstances. For example, is a crime against humanity. They include those which were listed as the treaty crimes in the IRC draft of the ICC statute, but which were excluded from the Rome statute in the course of the negotiations. Particular transnational crimes may in the future come to be dealt with as the international crimes within the jurisdiction of the international court. If states believe that the values they conflict with are sufficiently important to international community, and that international prosecution is an effective way of the dealing with them. This may, of course, occur with the terrorism and international criminal court. While each transnational crime deserves a detailed discussion itself in detailed lecture, for reason of space, only two categories, terrorism and torture, will be covered in this lecture, and thereafter definitely we will discuss the corruption, which is the one of the core crime of this part, that is the transnational crime. All of them, when committed in certain circumstances, may also constitute an international crime within the jurisdiction of the international courts and tribunals. The jurisdiction which the states are required to take differs from one agreement to another, but in case there is a close link between suspect and the state concerned, most agreements require states to take jurisdiction based on the territory and nationality. Some provide other opinions on grounds such as the nationality of the victim. For example, in the 1997 Convention for the Suppression of the Terrorist bombings, each state is required to take jurisdiction where the offense is committed in its territory, on its ships or aircrafts, or by its nationals. It is the permitted to take jurisdiction when the offense is committed against a national or against the state or government facility by a stateless person, or in any attempt to compel the state to action or inaction or when committed on an aircraft operated by the state. The agreements also require states to take jurisdiction so that they can prosecute if they do not extradite a suspect or their territory wherever the crime was committed. This is a last resort universal jurisdiction is between the state parties, which is dependent on the presence of the suspect. In fact, it is a fact the states parties delegate authority to other parties to exercise jurisdiction on behalf. So finally, because these agreements require that the crimes be prosecuted under the domestic law, they do not themselves describe in detail the material and the mental element of the offenses. Although states often adopt the definition by contain verbatim rather than further elaborate upon their definitions. As a unified system of the enforcement, they are weak. An additional criticism is that they largely rely on the domestic legal system to provide the necessary procedural rights for the accused during the investigation and prosecution. And these leaves scope for the human rights violations in those states which do not have adequate fair trial and other such protections in their concerns with law, and other states parties to agreements have neglected human rights requirements. In contrast with the way in which such requirements have been incorporated into the procedure of the International Criminal Court. So uh, it is the discussion on the how transnational laws mechanism working among these states because it is not still prosecute, investigate under the ambit of the cover of the international criminal law, but future maybe in the future the jurisdiction of the International Criminal Court will be considered because the rise of the transnational crimes and the importance because the forums now actively pushing and giving pressure to the states. They legislate their laws which combat not only combat but reduce those crimes which is not only harmful those states but also the effects of those crimes increasing in those states where they are not prosecuted or investigated in a uh, uh, well manner. Their effects definitely cross the boundaries of those states. So the importance of the transnational laws very much because transnational crimes means crimes which occurred beyond the boundaries of the states. So students, uh, students, in this part of lecture we have discussed the introduction and the certain topics regarding the future development of the international criminal law. Thereafter, another part of international criminal law that future of the international criminal law that is the transnational transnational crimes. So after a very short break, we will continue our this lecture and this part because the remaining topic of this part are the terrorism, torture, and corruption. So after a short break, thank you very much.